திருச்சி காஜாமலை பகுதியில் தமிழ்நாடு சுற்றுலா வளர்ச்சி கழகத்திற்கு சொந்தமான 4.3 ஏக்கர் நிலத்தில் SRM ஹோட்டல் இயங்கி வந்தது. இந்த ஹோட்டல் 1994 முதல் 30 வருட குத்தகை ஒப்பந்தத்தின் அடிப்படையில் இயங்கி வந்தது. 30 வருட குத்தகை காலம் 2022ஆம் ஆண்டுடன் முடிவடைந்தது. இந்த குத்தகையை புதுப்பிக்க SRM ஹோட்டல் நிர்வாகம் தமிழ்நாடு அரசிடம் விண்ணப்பித்தது. ஆனால் தமிழக அரசு அதை நிராகரித்தது. மேலும் ஹோட்டலை காலி செய்யும்படி SRM ஹோட்டல் நிர்வாகத்திற்கு நோட்டீஸ் அனுப்பியது. இந்த நோட்டீஸை எதிர்த்து SRM நிறுவனம் சென்னை உயர்நீதிமன்ற மதுரை கிளையில் மனு தாக்கல் செய்தது. இந்த நிலையில் நீதிமன்றம் கூறுகையில் குத்தகை காலம் முடிவடைந்த பின்னர் கால நீட்டிப்பு கோருவதை உரிமையாக கருத முடியாது. அதாவது குத்தகை காலம் முடிந்த பிறகு குத்தகையை நீட்டிக்க கேட்பது உரிமை ஆகாது என்றும் தமிழ்நாடு சுற்றுலா வளர்ச்சி கழகத்திற்கு சொந்தமான இடத்தை காலி செய்ய உத்தரவு பிறப்பித்தது. இதையடுத்து SRM நிர்வாகம் உச்சநீதிமன்றத்தில் மேல்முறையீடு செய்தது. இந்த வழக்கு அக்டோபர் 27, 2025 அன்று உச்சநீதிமன்றத்தில் விசாரணைக்கு பட்டியலிடப்பட்டது. உச்சநீதிமன்றத்தின் அறிவுறுத்தலின்படி வாடகை தொகையில் பாதியை, அதாவது ரூபாய் 20 கோடியை டெபாசிட் செய்ய உச்சநீதிமன்றம் ஏற்கனவே திருச்சி SRM ஹோட்டலுக்கு உத்தரவிட்டிருந்தது. வாடகை தொகை தொடர்பான சிவில் வழக்குகள் ஏற்கனவே திருச்சி மாவட்ட நீதிமன்றத்தில் நிலுவையில் உள்ளதை சுட்டிக்காட்டி திருச்சி SRM ஹோட்டல் நிர்வாகம் ஒரு இடைக்கால மனுவை மனு தாக்கல் செய்தது. மேலும் மதுரை உயர்நீதிமன்றத்தின் உத்தரவின்படி திருச்சி SRM ஹோட்டல் நிர்வாகம் ஏற்கனவே ரூபாய் 7 கோடி டெபாசிட் செய்துள்ளது. இந்த சூழ்நிலையில் இந்த வழக்கு அக்டோபர் 27, 2025 அன்று உச்சநீதிமன்றத்தில் விசாரணைக்கு வந்தது. ஆனால் அக்டோபர் 22, 2025 அன்று TTDC தமிழ்நாடு சுற்றுலா வளர்ச்சி கழகம் திருச்சியில் உள்ள SRM ஹோட்டலை நீதிமன்ற உத்தரவு இல்லாமல் உச்சநீதிமன்றத்தில் வழக்கு நிலுவையில் உள்ள போதிலும் வலுக்கட்டாயமாக கையகப்படுத்தியது. இதை பற்றி உச்சநீதிமன்ற மூத்த வழக்கறிஞர் சையத் அகமது சவுத் அளித்த பேட்டியில் கூறுவதாவது:
This hotel's possession which was taken over recently, this was in news. This fight was continuing for some long time. A lease has expired in 2024. When it was taken over, the site was given. It was upon our SRM's insistence, a lease deed was executed, and it had certain terms. It was for a duration in 96. It was executed for a duration of 30 years, but backdated to 94. So 30 years got completed in 2024. Now somehow there were several issues. So many representations were given. Those representations were mostly not considered. The issue of renewal or outright sale also of the piece of land. In that scenario, all of a sudden, some 18 years old rents were demanded and demands were raised retrospectively, enhancing the value of the land. So that suit was continuing. SRM filed a suit for stay on disposition, then filed a suit for claiming of rent beyond limitation, and then another within period of limitation, how much is due. Now, when this was pending, this was going on, then all of a sudden, TTDC, the government agency, entered into the premises forcibly. So, group was forced to approach High Court, and learned single judge of High Court restoring the possession to the hotel, the group. It highlighted an issue that nobody can be dispossessed by force in this manner. Ultimately, this issue traveled to Supreme Court, where court protected our possession subject to payment of certain demands. So we could not bring it to the notice of court at that time that the suits pertaining to rent are pending in trial court, and the issue, and we have already deposited 7 crores as demanded at that time under direction of High Court. So on next date of hearing, before court could consider, the possession was again taken by TTDC and the government. Now, in that scenario, court didn't hear us saying that you have not complied the order of depositing half of the total demanded rent. In this scenario, we could not bring it to the notice of court, though it was pleaded by respondent, the government TTDC, before court in their counter that possession has been taken over on 22nd, 5 days before hearing of the date of the matter. So this issue was not heard at all. Court did not proceed, said that you have not complied, and then it dismissed the petition. Now, the issue which is alive, which we want to bring to court's notice is that even a trespasser is entitled to some protection of law. We were leaseholders, our lease has expired. So for that also, there is a due procedure prescribed in law. Had we been a trespasser, we would have been given a notice under Public Premises Act for 30 days. We would have represented against that notice or eviction notice. On its rejection, appeal would have gone to district judge. So a procedure is there. Now, we had considered this aspect that unless we bring it to the notice of court by way of a review petition, that the possession which has been taken over by force is actually against the Indian Constitution guarantees under Article 14, 19, and 21. Therefore, we have filed review. We hope court would consider it and pass some guidelines that no lesser, be it a government agency itself, they are not entitled to trample upon rights and just enter premises by force. That is why we have filed review. So if there is any question, I am ready to answer. Please let me know.
இந்த சொத்து கையகப்படுத்துதல்ல அரசியலமைப்பு சட்டத்திற்கு முரணானது பற்றின கேள்விகளை நீங்க சார்ந்ததாக கேட்கும். இப்ப அது மதுக்கட்டாயமும் ஒரு கையகப்படுத்திருக்காங்க. தெளிவுபடுத்திருக்குமா இல்ல தெளிவுபடுத்த? Sir, he is asking, the acquisition was happened stably. Have you informed to the Supreme Court early, or you are about to inform to the Supreme Court about the forcible acquisition?
No, it was not adjudicated before Supreme Court. The forcible possession, as respondent TTDC and government filed a counter saying that we have taken over possession, but unless this is argued in court, it was not heard at all. And that is why we want to bring it to the notice of court by way of this review application.
Do you think Supreme Court can restore your ownership rights?
Sir, he is asking, do you really think that the Supreme Court will consider your review petition? Is that my question?
I'm very much hopeful for the only reason that the principle of law, as followed in all civilized societies of the world, and once a guarantee is given of due process and fair procedure, our job is to bring it to the notice of court, and we are hopeful that court would definitely consider it. At least this will become an example for the entire country to follow.
Sir, he is asking, is there any political motive in this case?
As lawyers, we are only concerned with facts and what as it happens. We don't know if there is any political motive, so I may not be in a position to comment. I'm sorry.
You have a big thing against they recover the properties. The properties they already exhibit petition, the case was dismissed, and EB also posted. Is it possible to, as it is by the law, they recover the properties and same for the previous stage?
Yes, for sure. Just like single judge, if you remember in the history of this matter itself, before High Court, when we went to High Court before single judge restored the possession and directed them to get out. Now, if Supreme Court considers our plea, then Supreme Court can definitely put us back in possession. But we at least want this law to be enforced, that nobody should be allowed to take law in their hands, even if they are government agency.
Another thing is, in the case hearings is coming date on 27th of October, sir. But what's the cause of the TTDC before the taking action and exhibit petition and go and they take a position in the court, sir? What is the based on the rule? Because the case hearing trial is coming on only on October 27th only. But previously, before the 5th day, what is the cause, what is the reason, and what is the strength is went to the court of position and take a position by the TTDC? Because of already, we are ready for the paying of all the actual amount. What amount of the Supreme Court they are paid it is, and what is the, they are ruling all the things, they are ready to pay the amount. But what is the reason they are petition to the court of party, and what a position to take a position in the court of before the 5th day?
I think looking at our petition, we were confident that at least Supreme Court will allow some more time, but only TTDC can tell the reason for that fear and haste. I cannot tell what was in their mind. For certain, if they have acted by force and taken up possession, I'm not sure what went in their mind, but still, we had very sound case because this principle of law is being implemented since times immemorial.
Sir, he is asking, the court has been already dismissed your case. So what will be your next move?
So this is what this conference is about. That group has already filed a review petition in Supreme Court itself to reconsider the order which they have passed, whereby the SLP was dismissed.
We have only one chance to consider the case is only the review petition only. Other than the area of the other, either is there to go for in the forward of the taking case and the argument and the of the rules and other things.
Sir, he's asking, do you have only one review option which is before Supreme Court, or do you have, you can still go beyond review petition also? Do you have any other option after review petition?
So it's a very good question. Sir, I have even received instructions to the effect that if the review petition is not considered, then we will move a curative petition before Supreme Court, where 3 senior most judges, they sit along with the bench which decided the matter, and they would consider that what is the point. Our review petition is based on this single ground only, that no one should be allowed to take possession by force. And if this is not considered by division bench of Supreme Court, we will go in for curative petition, which will be heard by 5 judges.
Another thing is the total basis only from the TTDC. So another all the properties, building and the business of running, all the things from the SRM only. And how that they have a right to possession of all the things. Because of they are giving only land, piece of land only. Because they are running the business more than 20 years. So we are ready to for all the payment of all the things we are ready to set it. And how they court dismiss the cases and we are taking the question of the before the trial of the day of the 22nd.
So what I have gathered is that, see, TTDC, the land was granted to us. Definitely, we building thereupon, and this hotel came up very well. It was in the posh area, working to the full capacity. Now, in the lease agreement itself, it was specified that in case this is not extended, then all removable items will be permitted to be taken away. We missed that chance. So as of today, we are not in possession of those. It's been blocked by TTDC. Even if we are allowed to take it away, that would take another 4 to 6 months. So in any case, this forcible possession could have never been taken had even the lease terms been implemented in true spirit.
Sir, he is asking, who are all the parties in this matter? Defendants. Who are all the defendants in this matter? He is asking.
So first party was TTDC, second party was government, and third party was district collector. I've even shared my review petition copy. If anyone wants to have a look at it, they may have a look at it as well. There may be so many questions answered in them.
Sir, he is asking whether your review petition has been admitted by Supreme Court or which is still pending, or when are you expecting the review petition to be heard by Supreme Court?
Sir, in review petition, it has been filed. Now it will be processed, and then under Supreme Court rules, it is not brought in open court. It will be considered by the judges sitting in their chambers. Lawyers are not permitted there. The moment court finds that, yes, this is an issue which must be addressed, then they put up for hearing in open court by giving notice to all the parties. So far, review petition has been filed, and it has not been brought before either of the judges of the bench. So it would take some time, but we are following it up. Hopefully, it will be heard soon.
Next, he is asking whether next bench will be comprising of 3 judges or 5 judges in this matter.
Next bench in this matter will be the same bench which will consider the review. Review always goes before the same judges which have passed the order. It's only thereafter, this matter, when it is filed for curative, then it goes to 5 judges. 2 same judges, the same bench, and 3 senior most judges.
Sir, in the next process, and how is the possibility, the percentage of the case will take into the trial and go for the winning of the petitioner?
The trial on the rent suits, there are 2 suits pertaining to rent amount outstanding as claimed by them. One suit is where we have read that the demand of the rent raised retrospectively beyond 3 years is illegal and is barred by limitation law. Therefore, that demand cannot be raised. Second suit pertaining to rent is that the last 3 years, the limitation period for the claiming of the rent, that amount of rent should be as per evidence. So both trial will continue. There is no effect on those trials. As far as suit for possession, which was filed by for suit for injunction from forcible dispossession, which was referred to mediation, where government is ex parte and TTDC is participating, is also pending before trial court. Now, that suit may have become infructuous, but we have rights under law to take back that possession taken illegally.
Maybe the status quo might பண்ணீங்களா இல்லனாக்கா SRM அது வந்து ரன் பண்றது அலோவ் பண்ணும் எப்படி? Sir, he is asking if review petition is allowed by the Supreme Court.
Yes.
Will they maintain the status quo or will it revert back?
For the consideration of the matter, they may direct status quo. But when it is decided that yes, they have taken over possession illegally, that can be reverted also. I think, Siva, you can share copy of review petition also. That would answer so many questions.
Sir, he is asking after the acquisition, how many employees were affected during portable acquisition?
I'm sorry, employees were there and then they had deployed their own team and they had not let some of the employees moved out. So our resident manager was, I think, not allowed to leave, but more facts can be disclosed by the person of the management present.
மாதிரியான வழக்கு நடந்து அந்த சயின்டிபிக் கேஸ் வேற மாதிரியான விஷயம் ஏதாவது உதாரணம் பொருளில் அப்படிப்பட்ட விஷயங்கள் எடுத்து போய் அதுக்கான ஜட்மெண்ட் வந்து
Sir, he was asking, is there any similar cases like the portable acquisition, and do you have any previous citations regards to the same matter? Any portable acquisition which has been released?
The foremost in the first example of this case itself, when it went to the single judge, it went with the plea of that they have taken over possession by force, and single judge gave an order directing them to restore the possession. So it's court's duty to put the clock back. Our job is to bring it to their notice that this has happened in this fashion.
Yeah, you plan to put up any other citations case for the in our case, putting up any other citations for the.
Yes, there is a plethora of judgments where this aspect, this principle of law has been reiterated that no one should be allowed to take possession by force. We will be citing all of those.
Where is the basis the violation of Indian constitution law by this case?
Sir, he is asking, you have mentioned Article 14, 19 and 21, where it has been caused in this case.
See, Article 14 guarantees equal protection of law. Article 19 for protection of right to carry on business, and Article 21 is right to life, but it is also a article wherein due process and fairness in the procedure has been enshrined. So the way the possession has been taken over, it has violated all of these articles.
Sir, do you have any other separate case has been filed since there are a lot of people who were staying, right? While people were staying, TTDC has supposedly taken back the land. Is there any separate case for that?
No, that if any person who was staying and they file a complaint against us in consumer forum, definitely TTDC will be implemented. It is their action. We have not caused them any harm, but it is TTDC's action which has caused the harm.
It go only for the consumer forum only, not any other law, because of they paid the amount in the hotel because they have a communication with the consumer forum, they pay the amount. They have a bill also. They go for the legal as the consumer forum only because they unable to evict the person to compulsory consideration. What's the question? You think it's because the people go for the legal action by the consumer forum only.
He is asking, they can approach only the consumer forum or do they have any other legal remedies before the other courts?
they can also join in if they want. They can also file an application before Supreme Court in our petition that this is the effect, and that can also be considered by court. Any other thing which comes to their mind after reviewing review, they can send it to Siva by email. We'll answer them.
Thank you so much. Thank you so much for your time and
My pleasure. Unfortunately, I couldn't meet all of them and see them, but at least they saw me.